All right, I think we're ready. Ms. Rivers, are you ready? Great, thank you for being here. This is 2022 EX, then 4 zeros, and the number 24. And we are having a hearing this morning concerning a motion that has been filed on behalf of Governor Kemp by his lawyers, seeking to quash a subpoena that has been issued for his appearance before the special purpose grand jury that is investigating alleged electoral interference in Georgia's 2020 general election. Why don't we start, because I think there may have been some last minute additions to the ranks of lawyers here, by having counsel for the governor introduce themselves, get themselves on the record. We'll figure out who from the state, meaning the district attorney, is going to be confusing with the state here, who from the district attorney's office will be talking as well.
Good morning, Your Honor. Brian McAvoy on behalf of the Office of the Governor.
Good morning, Your Honor. Derek Bauer, also for the Office of the Governor.
And Your Honor, we're also joined by David Dove, who's Executive Counsel for the Office of the Governor.
Excellent. Welcome, all three of you. And Mr. McAvoy, you're free to divide up the speaking in any way you want. All I ask is that only one person at a time make a point. But if Mr. Bauer is going to be handling, I'm making it up, executive privilege, and Mr. Dove's going to be talking about electoral cycles, fine. But let's try to keep sort of one person per topic, if that works.
Yes, Your Honor. Just for your Honor's understanding and to facilitate, Mr. Bauer will be handling the issue of sovereign immunity. Mr. Dove is just here as a client representative and can answer any questions that Your Honor may have, and I'll likely be handling the other components.
Great. Sounds good. And on behalf of the District Attorney's Office, good morning.
Good morning, Judge. Nathan Wade here for the state, along with Donald Wakefield here for the state. And with us will be Will Wooten and Adam Ney, District Attorneys for the state as well. The arguments will be handled by Mr. Wakefield and myself. That's okay.
It is okay. Same rules. Just try to keep one person per topic, or at least have a clear dividing line so that Ms. Rivers can more readily follow along.
Yes, sir.
Okay. So, Mr. McAvoy, I'm going to hand it over to you in a minute, just so you know. I've read the motion and the response. I can't say I've read all the emails. I don't particularly want to hear a lot about the emails, but it may be germane. And so I don't mean don't talk about them, but we don't need to get down into, well, that's when he called me a name in the email from August 14th. I get the drift with what the emails were about, those that were included and those that weren't, et cetera. But in terms of the thrusts of the arguments made by the Office of the Governor, in order of appearance, sovereign immunity, executive privilege, attorney-client privilege, and then interference with the electoral cycle. You can handle them in any order you want. I'm just, the way I processed them was the way they were in the brief. And the basic argument is that the governor hasn't waived his immunity from, I guess what we'll be discussing, how a subpoena in connection with a criminal investigation is a lawsuit, but that's why you handed that one to Mr. Bauer. Then we can talk about executive privilege, its existence and application in the state of Georgia. And then we'll manage attorney-client whatever way you want. And same with the concerns about scheduling. Okay.
Thank you, Your Honor. I had some introductory remarks that I don't think are really necessary. I think Mr. Bauer could probably just go right into the sovereign immunity argument.
Great. And I guess what I'll do while Mr. Bauer strides to the podium is if we get deep enough into sovereign immunity, I may turn to the district attorney's office to get their response to that topic rather than have the governor's office cover all four. And then I'm trying to remember what was said about sovereign immunity. So Mr. Wakeford, Mr. Wade, just be ready. It may be that you're bouncing up 4 times rather than just once.
Your Honor, just one housekeeping item. We do have a sort of a PowerPoint in some exhibits that we may or may not go through. I've got a complete set for the state and a set for Your Honor.
Sure. To that end, the best way to share things would be to join the Zoom session. And I think you got that link. And if you did, then you can share your screen. I don't currently have you in the Zoom call, but maybe your law firm has a way that penetrates our Zoom system from a satellite somewhere, and it's going to come that way. But otherwise,
Figure that out.
okay.
Can I approach and just give your honor?
Sure.
hard copies?
But please don't like plug things into things because that may disconnect something. So the best way is to join the Zoom and then share screen. Thank you.
Well,
They're marked.
You want to wait for them to be ready?
Proceed. The pleasure of the court, Your Honor.
If your first thing is on a slide, I'm happy waiting. I don't know.
I can talk for a few minutes before we get to the slide.
Let's get rolling.
All right. Well, good morning, Your Honor. It's a pleasure to be here. As you know, the governor's motion to quash the subpoena is on 3 grounds: lack of jurisdiction, that's sovereign immunity, improper purpose, and failure to accommodate important privileges. As Mr. McAvoy just reported to you, I'm going to address the jurisdiction issue, and he's going to speak to the other issues. As the court knows from the papers, we believe the centuries-old doctrine of sovereign immunity precludes a county district attorney from using the Superior Court's compulsory process to subject a sitting governor to an inquiry regarding the performance of his official duties, absent some express waiver that does not exist. I know that the court is deeply familiar with the doctrine of sovereign immunity. I know you just issued a detailed order in which you had to immerse yourself in it.
Had a recent crash course.
That's right. In another matter.
Thank you, Solicitor General.
I do not intend to bark at the court about things the court already knows well, but because I do think this issue may be destined for additional review at some point, one way or the other, I hope you'll indulge a little bit of exposition on that issue. I do feel like to start off, and I think Mr. McAvoy may have been intending to do this in his opening remarks, but you indicated in response to the motion when it was filed some bafflement as to why we are in the position we're in, why you were getting a motion to quash on sovereign immunity at this point in this investigation. And
by point, I meant on the eve of the appearance date that had been carefully negotiated with input from the governor's office at governor's counsel's request.
Correct.
Okay, just so everyone understands.
Absolutely. Something changed, obviously. That was the issuance of a subpoena, and Mr. McAvoy will speak to the relevant details of those communications and what the governor's agreement or the agreement he thought he had with the district attorney's office was on that. But we're equally frustrated. When we got that subpoena, we were equally baffled because there are some serious limits to the authority of a special purpose grand jury. And I think more relevant here, the authority of a local county prosecutor when you are talking about using the court's process to compel the sitting governor to do anything in relation to his official duties. And so once that subpoena was issued, and we believe it was ultra vires, the motion became necessary. And I just want the court to know that its frustration is shared.
So the subpoena flowed from the scheduling discussions we had that yielded the date that was supposed to work for both the governor and his lawyer. It was after that discussion that the subpoena, I was under the impression that there had been a subpoena, but people just agreed we're going to change the date because there was conflict X, conflict Y, conflict Z.
It's not what happened.
So there's only ever been one subpoena issued.
One witness subpoena, that's correct.
Oh, okay.
There was a document subpoena several months ago.
Okay.
Your understanding is correct, Your Honor, and I can address those logistical issues, which were in part exacerbated by my own personal travel. I'm happy to talk about it.
Okay.
I'm happy to talk about it now or later.
No. Mr. Bauer's helping me understand why the motion came when it did. And there was something that changed, and that was a subpoena. So was it, and I may be asking questions, I'm not trying to do this to you that are Mr. McAvoy questions, but was it the plan that the governor was going to appear on that date, which I think was last week, without a subpoena? In other words, he wasn't asking for one, and then the district attorney's office can explain its own actions. Belt and suspenders, hey, we've got this understanding, but let's just send you a subpoena anyway, just to memorialize it. and you don't need to answer for the DA's office, but I guess more bafflement. If everyone had agreed that this is the date that the governor is going to come in and testify before the special purpose grand jury, as did his Secretary of State, as not his, but the Secretary of State, other people. If the only thing that changed was, well, let's make it official. Here's an invitation. It's a subpoena, but it's an invitation. What, I guess I'm confused. If there was an understanding that he was coming anyway, the subpoena, he could say, I don't need that subpoena. But now that it's a subpoena, he doesn't want to come. I guess I need to understand that better.
McAvoy's going to explain that.
He's going to get there
in crystal
Okay.
clear detail.
All right.
But there wasn't a firm understanding. There had not been an agreement on that date or the terms of that appearance, but Mr. McAvoy will expand on that and explain it. So the subpoena was new. It was not by agreement. It was not invited. It was not welcomed, nor do we think it was necessary. But more importantly, for purposes of the legal issue in front of you today, it's not legally proper. So the governor's position is very straightforward, Your Honor. Sovereign immunity is jurisdictional. No court can exercise jurisdiction over the state or its chief executive without consent in the form of constitutional waiver or statutory waiver that meets the criteria that the court is familiar with for such a statutory waiver.
So, Ms. Zola, you need to mute your machine. True with lawsuits, and maybe you're getting there. I know you're getting there, but let's get there, because to me, the real issue here is, how does sovereign immunity apply, if at all, in the criminal context? And I want to be very clear. No suggestion that the governor or his office is connected to criminal activity. I think if one were to summarize the theory of the investigation, the governor was almost the target of the targets. And so would be lowercase v victim of pressure to do things that one theory is were improper post-election. But it's in the criminal context. And so I did look long and hard at all the cases that were cited, and they all involve someone trying to sue governor, the state, whatever it is, lawsuit, civil action. And apart from the email exchanges, there's not a whole lot civil about what's going on with the grand jury right now.
So I'm going to address that particular point, the specific language, suit, lawsuit, action, where that shows up.
Okay.
Why that's not the limitation. I think it will be crystal clear when I'm done. But I think, given the DA's opposition, what they filed late Tuesday, I think I need to take a step further back. And while, as you know, our motion was based on jurisdictional issues arising from sovereign immunity, the opposition that the district attorney's office filed, I think, has raised another issue that we have to educate the court about today, which is the fundamental statutory limits of a special purpose grand jury and its authority, and by extension, the DA's. So their opposition appears to be based on two things. One, a fundamental misunderstanding of the grand jury and the county DA's authority. And two, a narrow reading of the word suit, the issue you just raised, that's neither legally, historically, contextually, or logically supported. And I'm going to deal with those in that order, if that's okay with the court.
Sure.
Now, I read the special prosecutor's brief Tuesday night, read it again last night, and what jumps out at me is they think their authority is unlimited if what they're doing is A, a criminal investigation, and B, their investigation. And there are no constitutional separation of powers or sovereign immunity or statutory limits on that jurisdiction and authority if what they're doing is a criminal investigation.
Well, I think that overstates it a bit. We've been navigating. There are all sorts of limitations. There's attorney-client privilege, there's legislative privilege, et cetera. And the district attorney's office has pushed against that, but ultimately acknowledged there are certain things that even in the Fifth Amendment privilege that stand in the way of unfettered inquiry with the witnesses who do appear in front of the grand jury. So,
but you only get that far. You only get to analyze whether they have to respect those privileges if they have, or more importantly, the special purpose grand jury has the authority to do whatever it's doing anyway.
agreed.
And we've got to go back now and look at what that authority is, because their position that as long as what they're doing is a criminal investigation, there are no limits on that, and they can haul in the governor and they don't have to pay attention to these other jurisdictional constitutional issues. It's wrong on every level, starting with, this is actually not a criminal investigation. So slide 1 I put up here for you. This is a civil investigation. And in civil investigations, a special purpose grand jury and the district attorney that's aiding it have no authority under established Georgia law to investigate state offices. They simply don't. And I said civil, and I saw the court's reaction to it, but that is what a special purpose grand jury does. And I think the court has actually recognized this, albeit indirectly, in some of your other orders in this matter. You know, they keep saying it's a criminal investigation and it's their investigation, and it's neither. The investigation and understanding why those are both wrong is crucial to understanding what the special purpose grand jury is authorized to do and what it's not. And we got to look at that before you even get to, can they use it to haul the sitting governor in to testify about his duties? So we're lucky the Georgia appellate courts have actually answered this question for us. So number one, it's a grand jury investigation. It's not a DA investigation. While the DA aids it, it's the grand jury that investigates. I know the court is very familiar with that construct. And because it is a special purpose grand jury investigation, it's by definition, it's civil and it's not criminal, no matter how they want to dress it up. And this is because the special purpose grand jury is a civil investigative body only. It has no power to indict. And this is what I think Your Honor has noted in some of your other orders in this case. It doesn't have any power to indict. It has limited power to interview witnesses, and it can only issue a report. There's simply nothing criminal about its process or investigation. And whatever it does in that process and that ultimate report, they belong to the grand jury. They don't belong to the district attorney. So this slide tells you what the Georgia Court of Appeals has said about the nature of the special purpose grand jury. And there's a number of cases about them. The first one was this State versus Bartell case from 1996, in which the Court of Appeals was trying to figure out, does it matter whether this grand jury came under the special purpose statute or the regular grand jury statute? And they said, no, it doesn't matter, because what this particular grand jury, the regular grand jury, is doing was civil, not criminal in this particular case. Either way, we don't have to add to that question, but special purpose grand juries only do civil investigations because they can't indict. That was reinforced in Kennerly versus State in 2011.
Why does the lack of power to indict, and I agree with you that the special purpose grand jury cannot bring charges, and we've had to explain that to some witnesses, to all sorts of folks. Why does that mean it's not a criminal investigation or criminal investigative body as opposed to civil? Wouldn't one look to, I'll call it the charter? So the chief judge signed an order authorizing the creation of the special purpose grand jury. And its purpose was not to investigate civil matters. It was to investigate alleged criminal interference with the 2020 general election.
Yeah.
So criminal, not civil. Why is simply the lack of the ability to indict? A police officer cannot indict anyone.
Sure.
But if a police officer is asking you questions, that's not a civil investigation. It's a criminal investigation.
Sure. And it would trigger different constitutional concerns, obviously. And, you know, the Court of Appeals cases that have answered this, and they're the only cases in the state that have actually looked at the nature of a special purpose grand jury on this question. They haven't expanded, you know, particularly helpfully on that distinction. But I think the reason is because, particularly when you are investigating state or even local government actors who have special immunities that ordinary citizens may not have, then criminal versus civil, the nature of the investigation that the grand jury does, becomes a structural issue with respect to, you know, are you subject to jurisdiction? And if it's civil, if you're talking about government officials acting in the course of their official duties in a civil investigation, particularly when you're talking about the state, sovereign immunity is a bar. And so I think this rule is recognizing that when you are investigating a criminal act and you have probable cause to believe there's been a crime committed, by definition, that's outside the scope of an official state duty. And so I think that's where the courts are drawing that distinction, and answers your question, but we don't have clarity from the appellate courts about your specific question, is it indictment or no? But in these cases, and I'll urge the court to read them, they say if the grand jury can't indict, if it can't make a presentment, and all it can do is issue a report, then it's civil, it's not criminal. And they view that distinction as important. But here's why it's particularly important in this case.
What about on the federal level? Because I know this isn't your space, but this executive privilege is being imported from a lot of federal cases. So federal grand juries, they can investigate civil, they can investigate criminal. If it is a criminal investigation at the federal level, but it's merely designed, I guess it's tricky because there are no special purpose grand juries. That grand jury is a multi-purpose tool. It may be used at that point only to investigate. And the U.S. Attorney's Office gathers enough information and says, we choose not to present an indictment to that grand jury.
Right.
But what do you know about what federal case law says about sovereign immunity and a federal grand jury if the focus is criminal activity, not hey, should we have remunerated the people whose land we took more, but it's focused on a RICO allegation?
I know enough to be dangerous.
Okay. For your side or the other side?
For everybody.
Okay.
I don't want to tell you, with certainty that I'm about to tell you an issue of law that I'm correct on, particularly with respect to a federal criminal investigation of a sitting executive officer, right, of the president. I think the Supreme Court has said you can't do that while the president is in office.
Okay, but this is not an investigation of the governor. It is not an investigation of the governor. Again, as I understand the theory of the investigation, if the governor were to fall into a category, it would be victim in his official capacity. So that's not the right framework, because I understand that there might be limits to say you can't executive, but Department of Justice, you cannot use a grand jury against a sitting executive president to investigate that individual, but that's not this situation.
It's not. And I think the federal cases that are applying sovereign immunity to subpoenas give you that roadmap, right? They are telling you that unless the state has said one of our people can be a witness in your proceeding without sovereign immunity being waived, you can't do that. But the Supreme Court has looked. It's interesting to see that they cited the Paula Jones case against Clinton to say, look, we can haul in a sitting president if we want to. I mean, the Supreme Court in that case said that conduct has nothing to do with the discharge of his official duties. Right. You can call him in for a deposition, but I think what's interesting is they said that case ain't going to trial until he's out of office, because you cannot interfere with the performance of his official duties. I don't think this is any different. And Mr. McAvoy can talk about, the ethical guidelines that go to prosecutions and why, separate apart from whether there's a Supreme Court case that says federal grand juries can't haul in the president to be a witness in investigation of some other person's crime. DOJ guidelines say you don't do that during an election season. Even if you've got a really good reason to talk to somebody, if they're in an election and you have authority to talk to them, you still don't do it.
All right,
so that's
we're getting off topic. We'll get to that. So,
all right. So here's the problem. You've got these cases. Can you go to slide 2, please? Great. You've got these 2 cases that come out of the Georgia Court of Appeals, these Floyd County cases. And these related to a grand jury that Floyd County had. There are 2 different grand juries, 2 different cases. But what the Court of Appeals said in these 2 cases, and the one you need to look at in particular is the Henry Floyd County grand jury presentments for May term 1996, 225 Georgia App 705 at the bottom of the screen. Court of Appeals said, look, you're a county grand jury. You do not have any statutory authority to investigate state offices or state officers. Particularly in this, that the one I just quoted you was was not a special purpose grand jury, but it was conducting a civil investigation, just like this special purpose grand jury has to do. It says you can't use a civil investigation, local grand jury, to write a report that is derogatory to a state officer. That is beyond the scope of your authority. You can't do it.
You keep calling it a local grand jury. What is the local part, other than to make it sound like we're out in the sticks?
Well, I think because there's a distinction in the hierarchy of sovereignty in the state between state and subordinate political bodies, and a county grand jury, which is authorized by a county superior court judge, who by all means, whose authority we respect greatly.
But that wasn't my point. But there's no other grand jury in Georgia. There's federal
That's right.
and there's a state grand jury. This is a state grand jury. It doesn't have statewide authority necessarily, but I just want to make sure I wasn't missing something that the Attorney General believes, well, I actually could convene a special grand jury that has statewide.
It's a grand jury that is required to be convened by a county superior court judge who's elected by a local county electorate, not statewide, and overseen generally, unless there's an attorney general involved, by a local county prosecutor. And so I think what this case is saying is, look, these two cases, if you can't, the state has not suborned its sovereignty to these local bodies in this way. If you're going to investigate the state in this state, that authority rests with the attorney general, the governor, ironically, and the General Assembly, and each of them have been given that authority by statute or constitution or both. So, you can look at them. OCGA 45-15-17 is the statutory authority that says, Attorney General, you can investigate state offices. And then 19 is General Assembly, you can do it too. What you won't find, and what these cases say you can't do, is have a county grand jury doing a civil investigation of state officers or state offices. So I point this out just because, reading their position, which is as long as we think it's criminal, we can do what we want and we're not bound by any limitations, made me have to go back and look at this and say, well, wait a minute, is this a criminal investigation? And the courts say special grand jury can't do that. And do they have the authority to go beyond their local jurisdiction and haul in state officers? And all of these statutes and these Court of Appeals cases say you can't do that. You cannot usurp the authority of the AG and the General Assembly or in the governor for yourself as a state prosecutor.
Because in Floyd County, they were investigating DFACS, which is a state agency. And it was an investigation into the operations of a state agency, et cetera, which that grand jury thought, hey, we're able to inspect our clerk's office. And I don't know what gave them the wild hair to go after DFACS. Again, not this situation.
So, but what they were doing, they can still subpoena records from DFACS. It's interesting that the grand jury's authority does allow them specifically and expressly to get documents from state departments. But what it can't do, and what this court says was quashed in that case, was you can't subpoena DFACS employees. And we weren't even talking about the head of DFACS, we're talking about low-level people.
Right. In an investigation into the operation of DFACS, as opposed to an investigation into maybe there was a hacking attack on DFACS. And so they're just trying to figure out, hey, you were a victim of hacking. Tell me what you saw on your computer screen when the ransomware appeared. That's different.
Okay.
I think, but who knows?
But I'm sure the grand jury could have articulated a narrower way to phrase what they were trying to investigate that made it less direct on DFACS. But either way, the Court of Appeals says, if you want to talk to state officials, that's the AG's purview. That's the General Assembly's purview. That's not something you can do here. But that's just the statutory limits that the courts have put on grand jury authority. And there's no recognition of it at all or the fact that the special purpose grand jury is civil. By definition, it can't be anything else. And
you say that because of Bartell
and Kennerly, yes.
Kennerly just says it can't indict, but you marry the two to say because it can't indict, it must be civil.
I think that's the clear implication of those cases.
Okay.
But we don't even need to go there. I mean, we needed to make our record because they've attacked or demonstrated that they do have statutory authority to do it. We don't even have to wade through that thicket to dispose of the subpoena because sovereign immunity is not structural. It's not based on suit or lawsuit or action or claim or any of those, words that you can interchange and are interchanged in law. It is jurisdictional. So can you go to slide 3, please, Grace? I know the court's aware it's a common law jurisdictional doctrine. It actually predates the charter of the state of Georgia and our first constitution, but it was constitutionalized in 1974. So we don't have to worry about, is it common law or is it constitutional? It is constitutional. And it is jurisdictional. The McConnell case in 2017 and the Conway case makes it very clear that it is not structural. It is jurisdictional, as do half a dozen other cases in the state that have reviewed it. Now, the special prosecutor argues that sovereign immunity is tethered to the nature of the legal process at issue, as if it matters what form of legal process is being asserted against the state. And I'm going to show you that's not the case. The entire argument appears rooted in the issue that you've raised, which is their belief that the word suit appearing in certain provisions of the Georgia Constitution that provide for express waivers of the jurisdictional immunity means that sovereign immunity only applies in the context of an actual complaint filed, naming the state or its officers as a nominal defendant. But when you look at how that word suit or lawsuit or action, those words are actually used in the Georgia Constitution with respect to the application of the jurisdictional bar, it's clear that there is no such limitation, because the provisions in the Constitution that say we, the state, are immune from jurisdiction, they don't have that language in it. And I'm going to show you why and where that is. And there's no other defined mechanism of process at all that limits that jurisdiction. So, even if you accept his argument that suit or lawsuit means a complaint or a petition or some defined cause of action, which according to Black's Law Dictionary, by the way, that's not what those words mean. It doesn't. So let's look at the Constitution. Can you go to slide 4, please? So this is Georgia Constitution, Article 1, Section 2, Paragraph 9. This is the primary provision in the Constitution that provides for sovereign immunity. And up until the amendment a few years ago to the Constitution was the sole location in the Constitution where you would find any waiver. So the key provisions in here that actually provide for they incorporate the common law sovereign immunity are subsections E and to a lesser extent F. So let's look at primarily E here. E is the actual expression of the immunity the state enjoys. This is the source language. Except as specifically provided in this paragraph, sovereign immunity, no limitation, no suit, no action, no lawsuit. It extends to the state and all of its departments and agencies. The sovereign immunity of the state and its departments and agencies can only be waived by an act of the General Assembly, which specifically provides that sovereign immunity is thereby waived in the extent of such waiver. That is not limited. It is not limited to any specific cause of action. As you know, you very articulately laid out the history of the Supreme Court's look at these provisions over the last 10 years. Last week, they are issuing opinions that expand the scope of that and clarify, making sure that people who are concerned that they don't know what it applies to know it applies to everything. But if you look at this source language, it is not limited. It doesn't say sovereign immunity, the state enjoys it only for suits, lawsuits, actions, claims. That's just simply not what it says. So where does that language come from? You can find it in the exemptions, the express waivers, and only there.
And they're all for civil actions.
And they are specifically identified. So the only place those limiting descriptors show up is when they are in the Constitution explaining the limits of those express waivers. So you got the Constitution saying we are immune unless we tell you otherwise.
But immune from what?
Jurisdiction. You can't bring me into court for any reason. It is jurisdictional bar. The state is above the reach.
Where is there a case ever that says that includes criminal proceedings?
It doesn't have to unless there's an express waiver for it. Now,
but then there'd be a case that says, oh, you actually can't haul this person into court for criminal proceedings because of sovereign immunity. One of these local prosecutors, the local judge would have tried it. And if sovereign immunity prevented a state actor from being hauled into court in connection with a criminal investigation, there'd be a case about that. And your brief says nothing about that. So well, I guess that's what we don't need to quibble about what suit means. Pick your word, suit, action, complaint, etc. The dividing line, as I understood it, civil and criminal. And there were no cases in your brief. You have mentioned no cases yet. It's what I would have led with. Oh, look at this case from the Georgia Supreme Court, Georgia Court of Appeals, wherever it says, hey, sovereign immunity also applies to criminal actions. Because, of course, the state is an actor in a criminal action. And so this notion of importing sovereign immunity gets kind of sticky because it's state versus state. And I appreciate you've used the word local in front of everything. But if there were an indictment from the grand jury that processes the special grand jury report, that indictment wouldn't say local Fulton County. It would say state of Georgia versus list your people. Some of them might be state actors. And I don't believe those state actors could say, oh, sovereign immunity, you can't indict me. But I could be entirely wrong. I'm just waiting to see that case that says if you're in the criminal realm, sovereign immunity doesn't apply. Isn't that the argument of the district attorney's office?
Okay, so that appears to be their argument.
So pretend it's my argument now. Say why that doesn't work.
Just because you label it criminal doesn't make it a criminal proceeding.
Okay.
Courts have said that, right?
And that's your argument that, look, this special purpose grand jury, it's actually a civil thing. And if you're right, civil, I agree. Sovereign immunity, I don't see any waiver anywhere. But indulge me for a moment. So you know what? It's a criminal investigation. The only discussion is criminal statutes. The only concern is, was there criminal interference with the 2020 general election in Georgia? So it's a criminal investigation. No jurisdiction?
It's an investigation into whether a crime was committed, but it's not a criminal investigation because it cannot result in any criminal indictment or presentment being made. That was the choice of the district attorney when they opened this investigation. They chose to go the route of a special purpose grand jury that can just write a report. That's all they can do. And that doesn't convert this into a criminal inquiry where, and I don't think it's settled by any stretch that even if this were a criminal grand jury proceeding, that the DA could summon the governor to it as a witness only to talk about the performance of his official duties while he sits in office.
I don't know if it's settled, but you haven't shown me anything that says that couldn't. I guess I'm curious if it were a GBI investigation. So they can't indict anything either. And they're trying to interact with folks and they try to get legal process to do something. Sovereign immunity? Nope, you can't do it because we haven't waived it. It's not. I think what you're bumping up against is the fact, even though it doesn't say civil in Article 1, Section 2, Paragraph 9, sovereign immunity applies to civil action suits against the state. But if it's criminal, it is the state. The state is the actor.
Justice Blackwell gave us the history lesson a few years ago.
He was and Peterson. I mean, we got a lot of history lessons.
We've got a lot of lengthy decisions, but they're not really complicated. And what they're saying is, and the reason we had this constitutional amendment a few years ago is because that Lathrop versus Deal case came out and basically said, sorry, guys, you got nobody to sue. We don't.
To bring a civil lawsuit against.
In that particular case, yes. But what they said was the sovereign immunity is a jurisdictional bar that is virtually absolute. Broad sweep was the language they used, and dates back to the sovereignty of the king. It's not about the nature of the process or the nature of the tribunal. It's about whether the state, like the king of old, has consented to jurisdiction. Now, you know, the king of old couldn't be compelled into any court they didn't want to go to. We're a little bit more sophisticated than that. And we've said, you're the king, state of Georgia, which includes its chief executive, the governor. But we're going to carve a little bit out of that. And we're going to say, unless the state has put it in the Constitution or the General Assembly has done it and the governor ironically signs it,
right?
You're above the law as far as process and tribunal is concerned for your official duties. And this is really the key point here. They are not trying to summon the governor to talk to him about things that were outside the scope of his official duties. They want to talk to him about what he's doing in office, performing his duties. He's the king for purposes of sovereign immunity's jurisdictional bar, unless the Constitution or the General Assembly has said otherwise, and they haven't. Now, you're not going to agree with me. I don't think that the special purpose grand jury isn't criminal, it's civil. And I think that answers the question, but the governor is not above the law. He's never contended he's above the law.
He's just the king.
Subject to the limitation, he's the state, right? He's not the king, he's the state. But that immunity of the state, which his office has to enjoy and protect, not just for the performance of his duties, but for the next governors and the next governors. Yes, the state enjoys, in the Supreme Court's words, absolute immunity unless it is consented otherwise through these processes, General Assembly or Constitution. It doesn't exist. And I don't think we or the governor have the luxury of pretending that that immunity doesn't exist and is a jurisdictional bar because it's politically convenient for him to do so. Mr. McAvoy is going to talk to you about all the efforts that the governor has made to try to engage with this investigation. But once that subpoena issued, he was put in a position where he had to either enforce the law of the state of Georgia, which includes making sure that there is no inadvertent waiver or derogation of this important immunity that the state enjoys, and he is duty bound to protect.
Is there a
enforcing it.
particular reason we're having this discussion now and not when? I think this is how it played. I may be mistaken. The Secretary of State, fall under this definition, received a subpoena. The Attorney General, the Chief Law Officer of the state, received a subpoena. Why is it the king rather than his chief counsel or the Secretary of State?
It's a fair question, and Mr. McAvoy and I would have very much liked to have been
Engaged
counsel to those gentlemen before they made their decision, but they do enjoy the same sovereign immunity.
It'd be the same argument, and they could choose to enforce it or say, I'll honor this subpoena and let this grand jury hear what I have to say.
The court is sophisticated enough to know that both of those state officers may have had independent reasons. One primary one being the timing of the outreach.
Right. Months ago.
For and scope. We don't know what kind of discussions their legal team had with the district attorney before they agreed to come talk. We don't know if they were reassured that their executive privileges, their attorney-client privileges, the scope of the questions would be limited and appropriate. We just don't know. That's questions that I think they would have to answer, but sovereign immunity is not theirs to waive. And while the Attorney General is one of the law enforcement officers who has a duty to uphold the law in the state of Georgia, the governor is the chief executive. Mm-hmm. And the Constitution is very clear that he doesn't have the luxury of ignoring something as important to the state's continuing operations as this jurisdictional principle, merely because he was going to be put in this awkward and uncomfortable situation where he's, being disparaged on a daily basis for the way this process has unfolded. So he did not choose to have the subpoena implicate this important jurisdictional doctrine, but it did. As soon as it was issued, he was left without a choice if he was going to fulfill his constitutional duty to make sure that that immunity is upheld and protected. The court.
Well, I want to follow. I follow most of that. When you say he was left without a choice, are you saying the governor didn't have the same liberty that the Secretary of State or the Attorney General and could have elected? It would have set a precedent that governor in his wisdom would have made, but could have said, all right, you know what, I'm going to show up anyway. I don't necessarily think this is something that has jurisdiction over me. It's a piece of paper that I could choose to ignore. Or as you said, he had no choice but to.
Yeah.
And I assume that was to defend. Okay.
So, and it's rhetorically because, honestly, these proceedings are supposed to be secret, the grand jury's investigation. Yet somehow this stuff plays out on the front page of the paper, seemingly multiple times a week. I don't actually know whether the Attorney General and the Secretary of State were subpoenaed or whether they appeared voluntarily.
Okay. Me neither.
But Mr. McAvoy is going to tell you at length what efforts the governor made to engage voluntarily with the district attorney's office. So the change, the duty to make sure that he is not complicit in an unauthorized investigation that's exceeded its authority came when that subpoena issued.
Okay.
We kind of talked jokingly about the state being the king, and I'm not trying to suggest that the governor views himself in that way. I have to clarify because we've got lots of people watching.
Understood. And me neither. And you were simply going historical. And
that's right.
The term is sovereign immunity. There is no sovereign in America, but there is a head of the government and the head of the executive branch and our duly elected governor. That would be where sovereignty starts.
That's right. And the principle derives from the king. And so you have to understand that context to properly apply the principle here. But the governor doesn't think that he is beyond any reach of law. He's just beyond the reach of this particular subpoena because there are other mechanisms if the state needs or wants to investigate the official activities of the governor. That legal authority does exist. It just doesn't exist with this special purpose grand jury. It exists with the Attorney General, with the General Assembly on multiple levels. And constitutionally, there are proceedings, we've seen them at the national level, where the legislatures can hold the chief executive accountable for violations of law or other misconduct related to the official performance of his duties, but they get to do it under
Sure.
separation of powers, not this
With a
jury.
slightly different setting again. Again, my understanding is not that the purpose of the subpoena was to hold anyone accountable, but to gather information, investigate. It's a body that can't hold anyone accountable.
Right.
So.
So I'm going to wrap up, I think, with that point. The governor wasn't looking for an unnecessary fight with an important branch of his administration. But he does need to defend the important constitutional and statutory limits of the grand jury's authority to protect the next sitting governor from what, I'm not suggesting it's misuse here, some might, but the next governor needs to know that his office is protected from perhaps an overzealous administrator of a special purpose grand jury. So we are here asking the court to follow the clear law, what we think is the clear law of the state, and hold the special purpose grand jury to that law, to its statutory limits and to its jurisdictional limits. We think the subpoena is ultra vires, is due to be quashed for lack of jurisdiction. And I'll leave the court with this. It's kind of where I started. If there's any doubt in the court's mind about where these lines are drawn, we're going to need appellate clarity on this. And the proper avenue here is to defer to the protection of the constitutional principles and the state's sovereignty, defer to the jurisdictional bar until the appellate courts tell us that's not the right way to do this, to answer the questions that you've asked. So we would urge the court, if you have questions or concerns about the reach of sovereign immunity here, that you give us the quash order and let the state take it up if they want, and we'll get the clarity from the appropriate appellate court.
All right.
Thank you.
Mr. Wakeford.
The opposing counsel just said, if Your Honor has questions, just quash the subpoena. But Your Honor asked several questions, and I didn't hear from opposing counsel answers to those questions. So this proceeding, which is clearly criminal, why is it civil? This proceeding, which is not a lawsuit, but instead a subpoena, why does sovereign immunity apply to that? There has still not been direct answers to those questions. And finally, where is the authority for this position? Where is the case that states that the governor can have his subpoena quashed in these circumstances? There were not answers to those questions. So I'm at Your Honor's disposal if you have questions for me, but our position is that this is a criminal proceeding. Sovereign immunity applies to immunity from suit.
What makes it a criminal proceeding? I guess what I'd like you to focus on is it's not quite exactly where Mr. Bauer started, but like page 2. Bartell, I understand what Kennerly says. Different sides have invoked Kennerly. I've invoked Kennerly. Just to let everyone know, this grand jury is issuing a report, not an indictment. That's the extent of their end game authority. To me, it's less clear the extent of their authority to summons people before them. What makes this special purpose grand jury a criminal proceeding as opposed to a special purpose grand jury that was investigating something plainly civil?
I think DFACS, if it was investigating the administration of DFACS, or if it declared itself a civil investigation. First of all, the Kennerly case is, when it says the language that the opposing counsel relies upon, it is interpreting Bartell. It says, Bartell says special purpose grand juries are only civil. That's not what Bartell says. Bartell says, in that case, that grand jury was civil and declared itself as such.
What do you know what the special purpose grand jury in Bartell was tasked to do?
The grand jury in Bartell actually wasn't clear which statute that grand jury was impaneled under. And the court in Bartell ultimately says, it doesn't matter because it says it's a civil grand jury. It could have been under the regular grand jury statutes or 1512.
Because it had to do with the oaths that were administered. And so, gosh, which provisions should they have used?
Right.
And I'll have to dive deeper into Bartell. But what would distinguish Bartell for me is if its charter was to determine if there had been violation of the city code in a non-criminal way with the way something was developed. It had nothing to do with alleged criminal activity.
And the part of the decision in Bartell is they say, we don't know which statute this grand jury was chartered under, so there is no charter. But what the oath in Bartell said is, do you swear to tell the truth in this civil investigation into the Department of Family and Child Services, was clear. And so the Court of Appeals said it doesn't matter. It could be under either because 1512-100, the special purpose grand jury statute, says that you can be impaneled for either. But you can impanel one to investigate anything that a normal grand jury can investigate. And a normal grand jury can investigate civil or criminal proceedings. So then we look, the language of the statute says that a special purpose grand jury can be convened to investigate any violation of the laws of this state. The impaneling order, which was issued by the chief judge of this circuit, said that any violation of the laws of this state can be investigated within the subject matter that is relevant for this special purpose grand jury. And in the request from the district attorney for a special purpose grand jury, it was said over and over that there could be possible criminal disruptions to the laws of this state. And that is what it is investigating. Over and over again, this has been emphasized. Finally, you have the authority of a special purpose grand jury who is investigating criminal matters to make recommendations in its report that certain criminal charges be pursued. So to say that because of a line in Kennerly that misinterprets the holding in Bartell, that this is somehow civil and there is no amount of other authority or specific information in this case can say otherwise it's just not true.
Let's say for a moment that it's fair to characterize the special purpose grand jury here as one that's engaged solely in criminal investigation. Why does sovereign immunity then not apply to the subpoena to the governor?
Well, sovereign immunity, look to the Constitution here. This was cited by opposing counsel. Article 1, Section 2, Paragraph 9. It may waive the state's sovereign immunity from suit by enacting a state tort claims act. We are talking about items and in matters that have absolutely nothing to do with a criminal investigation. Additionally, this is not a suit. This is if they had meant any legal proceeding conceivable, they could have said so. But this is talking about tort claims. This is talking about proceedings against the state where the state is a party. And this is a subpoena to the governor as an individual about his activities as a witness to the actions of other people.
Well, yes, but to Mr. Bauer's point, it wasn't a witness where he happened to be driving from home to work and there was an accident or he saw people in a fight. It would have the only reason he's connected to this is because of his official capacity. And as I understand the theory of the investigation, entreaties that he exercise his authority in certain ways to benefit folks who thought that the electoral outcome wasn't what it seemed to be. So yes, witness, and I've seen nothing that suggests the governor is anything but a witness, as in we're interested in learning from you, not subject, not target, to get into that messy nomenclature that raises pulse rates. But it is still in connection with his official duties, which is why I think we then need to explore the concept of sovereign immunity, because I think Mr. Bauer acknowledged this. If the governor had been driving home from work and was going 90 in a 35 zone and hit someone and there was a lawsuit over that accident, that would be victim of accident versus the name of the governor, not govern in his official capacity. And I don't think sovereign immunity would help him a lot there. But it certainly, if this were a civil investigation, this is the governor in his official capacity, responding however he did to people from the outside of Georgia and inside of Georgia saying, why not take this course of conduct? Why not do this? We ought to do that. So to call it his as an individual, unless I am, you are much closer to where this special purpose grand jury has gone. But on the surface, the layperson understands it to be the governor as governor and not as I happen to live in Georgia and these things happened.
That analysis of whether acts are official acts or acts in an official capacity is always undertaken after when there is a lawsuit. So to put that analysis ahead of the determination of whether this is a lawsuit or not puts the cart before the horse.
Okay.
It inverts the analysis, and it's just not relevant because this is not a lawsuit. This is a subpoena to ask the governor to be a witness in a criminal investigation. So it just doesn't apply. And if it did, I'm not sure if the implications of this position have been fully thought out and explored, because police officers are arms of the state and they are subpoenaed to appear in court proceedings all the time. I have yet to hear that a police officer or state trooper who is an employee of state government cannot be subpoenaed to come in and provide testimony in criminal matters.
GBI agent.
If this position is validated, the power of this court is entirely destroyed with regard to a whole host of actors. And it simply doesn't flow from logic or the way that the law is supposed to fit together. This grand jury has asked the governor to come forward in the same way that his legal advisor under the laws of this state, the attorney general, was asked to come forward. And as Your Honor pointed out, this is the first we are hearing of this argument. And yet the legal advisor to the governor has come forward. At no point was there a motion before this court from the attorney general saying sovereign immunity applies.
Okay, but that doesn't make the argument a stronger or a weaker argument. The timing is peculiar, but we've explored that. And Mr. Bauer, I think, helpfully reminded me there are a bunch of different reasons why different state actors would make different choices upon receiving an invitation from the special purpose grand jury. We're confronted with this motion at this point in time, and the merits of the sovereign immunity argument, I don't think hinge on when in the course of the investigation, or even more so when in the course of the interactions trying to get some communication between your investigation and the governor's office. It's come up, and we need to engage, all of us, both sides and myself, the merits of the argument and not so much the timing.
Aside from that, Your Honor, the application of the Floyd County cases, which specifically speak to the regular grand jury statutes authorizing specifically civil investigations into state offices, simply do not apply in these circumstances for reasons that should be obvious. This is not a regular grand jury authorized to investigate a civil matter. It is a special purpose grand jury specifically authorized to investigate criminal matters. So I believe our position is clear and was clear in the briefing and has been clear here today. There is no application of sovereign immunity in these circumstances. And this is not a lawsuit. Sovereign immunity would be, the application here would be in contravention of decades or centuries of practice in this state. They have presented no authority to indicate to this court that this court should grant quashal on this basis. And unless Your Honor has additional questions, I believe our position on this matter is clear.
I have one last, and I'm importing from the federal side, but this notion that summonsing in an active executive, sitting president, sitting governor, sitting mayor, the executive of whatever level of government you're looking at, that's the issue. So yes, maybe there's immunity, but there's also just the policy practicality of we don't do that because we need to let that individual perform his or her important function. And when the sun sets on that administration, then let's have that conversation with the person who occupied that office.
Well, there's no authority, again, for that position in the state of Georgia. There is no gubernatorial immunity from process, whether he is the king of the state or anything else. There is no basis in the law for a position like that. The governor is not the equivalent of the president. Additionally, I believe that there's sort of two considerations. They sort of say that he's the sitting governor and therefore he can't be pulled in, but there's no basis for that. And then there's also citation to cases under federal law that invoke the TUI doctrine, which is specifically promulgated in federal courts to say that federal bureaucrats cannot be forced to testify over without the authorization of their superiors. That is wholly a creature of federal law, has absolutely no application under Georgia law, and shouldn't impact this court's analysis at all.
Right. I think the word is agents and not bureaucrats, but yes.
Pardon me. Yes.
That is
Federal
what
action.
TUI does. That is definitely what TUI does. Okay. I appreciate that. Mr. Bauer, was there anything you heard that you just can't let go by, or can we transition to the next topic?
I get paid by the hour, Your Honor. I got to make 2 points.
Okay. Not by the word, by the hour.
Right.
Okay.
So I'll try to be brief. It is not our burden to show there's a waiver of sovereign immunity, right? Constitution says we have it. It's jurisdictional. The only way the governor in his official duties can be hauled into a court for any reason is if there's something, and maybe you've seized on something that I haven't found, that says if it's criminal and he's a witness, he can do it. You have the authority to do it. But under the construct of our Constitution, we don't have to give you that authority that says you don't have the authority. They've got to show you the authority for the waiver, and they haven't done that. They've said, we haven't done it, but that's flipping the burden on its head. The default is the state is immune from process, absent a waiver. They've got to show you the waiver.
That is indeed what the law says. If sovereign immunity applies to that situation. And so what I heard the state, meaning the district attorney's office, argument to be is we don't need to point you to a waiver because sovereign immunity applies to suits, actions, et cetera. And you've responded, I get that, but I think the two sides are talking past each other a little bit, and definitely past me, because you don't have the burden to show that immunity applies. They need to show there's a waiver. Someone has the opportunity to show me a case that says, oh, and by the way, that applies in the criminal context.
Sure.
And I just haven't ever seen that case.
Well,
We will soon.
This is a civil proceeding, so we haven't looked for that case for you, but we will. But the only limitations to lawsuits, claims, actions is when the General Assembly, and in that language that he pointed you to, I think answers the question, right? He pointed you to subsection A of Article 1, Section 2, Paragraph 9. It says the General Assembly may waive the state's sovereign immunity from suit by enacting a state claims act. That doesn't say the state only has sovereign immunity for suits. It says we're immune. That's what subsection E says, unless the General Assembly does something to reduce that. And what A says is we're giving you, General Assembly, direction that one of the things you are authorized to limit our jurisdictional bar on is a state tort claims act. So General Assembly, you don't have to worry about this sovereign immunity being a problem for tort claims against the state, because we are telling you in the Constitution, you can do that. You can say immune from suit by enacting a state claims act. It doesn't say these are the only things that we're waiving immunity from, or we need a waiver of immunity from. The only other point I want to make is I think you sort of highlighted the slippery slope of authorizing grand juries to subpoena a sitting governor during his term, during an election. Let Mr. McAvoy talk about that, to discuss the conduct of his duties in office. And, you distinguished the cases I cited for you by saying, well, maybe they were investigating defects, and that is beyond the scope of their authority. But what if the grand jury is investigating the mayor's office? It's not beyond the historical realm of possibility in this city. And what if the mayor, who in past times might have been in regular communication with the governor, as one would expect, with two important chief executives in the same state? Does that give every grand jury that's investigating a potential city crime the ability during a governor's term to say, you're going to come in here and be a witness in our investigation to talk about your performance of your duties in office? I think sovereign immunity says you can't do that. You have to find another way, state, to prove your case without infringing on the chief executive's immunities and privileges and separation of powers protections, unless we've said specifically, you can do it. Now,
Of course, the separation of powers is executive, legislative, and judicial.
Correct.
Love the third one. Prosecution, governor, they're all in the same branch. So we're not separating a whole lot when we're pitting a criminal investigation against your theory that sovereign immunity actually includes criminal investigations.
No, the reason it's a separation of powers constitutional concern, and I know that Justice Blackwell would have agreed with this, is because this is not the DA issuing a subpoena to the governor.
It's the grand jury.
The grand jury and this court. And that raises a problem that Justice Blackwell has written about, that I don't even know if the courts of this state could enjoin the governor in a claim in which sovereign immunity theoretically doesn't apply. So that's what I think the problem is here. We appreciate the court's time and attention to it.
You're welcome. What's next, Mr. McAvoy?
Your Honor, before we turn our attention to executive privilege, if I could just respond to one issue regarding criminality of the special purpose grand jury.
Okay.
I mean, I think an important distinction as you raised, and if you look at Rule 6 of the Federal Rules of Criminal Procedure and what federal criminal grand juries are authorized to do, that's return indictments. And in our view, that's the distinction between a criminal procedure and a civil procedure. Even in the federal context, you impanel a grand jury, you want to look at some civil FDA issue, that grand jury still has the power to return an indictment, even if it starts off as a civil inquiry. I liken it to law enforcement. Does somebody have arrest powers? They have arrest powers, it's criminal in nature. If you don't have arrest powers, it's civil in nature. And I think that applies here. And if you look at Chief Judge Brasher's order, the only thing that they're empowered to do is make recommendations. And in this country, making a recommendation about a criminal matter does not empower it to become a criminal matter.
Does the GBI ultimately make a recommendation to the Attorney General's office about whether to seek an indictment of a statewide gang matter that they've been doing?
So that's a little bit different, right? I mean, there is dual jurisdiction, and now the FBI has dual jurisdiction. The FBI can investigate something criminally, but make a civil recommendation. And we see that in the False Claims Act context all of the time. It's frightening for somebody like me, but it happens. But you can't have it the other way around. You can't have a civil investigator have arrest powers or indictment powers, just as a special purpose grand jury has no power to bring charges against anybody.
Okay. But my question was the fact that the GBI can't indict, but they could recommend to the Attorney General that he pursue an indictment following their investigation doesn't make their investigation non-criminal.
But Your Honor, that's not the province of a law enforcement officer. The province of a grand jury is to return a true bill or not return a true bill. That is the entire, as you well know, that's the forum of the grand jury. The forum of a police officer or a detective, they're not empowered to bring indictments. They are
understood, but the fact that they cannot bring an indictment doesn't make their investigation non-criminal. That's all I'm getting at. And this grand jury, this special purpose grand jury, much like a GBI agent investigating something, they don't have the power to indict, but they have the power to gather information and ultimately make a recommendation to the district attorney. Hey, based on what we've got here, we think you should indict. And I think I'm analogizing here. I want you to distinguish it the way that a homicide detective might say, you know what, we think you should bring this case. Or FBI agents would bring to an assistant U.S. attorney, we think you should bring this case. That's not a civil investigation until it's indicted.
Your Honor, that's not the role of a grand jury historically, is to either bring criminal charges or not. This is a unique body, right? They're not authorized to bring criminal charges. I understand that it's related to some potential criminal case that may or may not be made down the road, but they don't have the power to bring criminal charges. And we're just trying to make the distinction between criminal and civil. If you have the ability to bring criminal charges, it's a criminal matter. If you don't, it's not.
Okay.
Your Honor, I was going to address the executive privilege issue. Some of the other issues that we're going to discuss are kind of interwoven between one another. And I just wanted to provide a little bit of context, historically as to why we're here and how we're here. And one thing Mr. Wakefer said is that Governor Kemp was, quote, asked in the same way to be here as Secretary of State and the Attorney General. I think that's not really true, and we'll sort of walk through that. But it's important to note, by way of background, as Your Honor has, that Governor Kemp is just a witness in the matter. Governor Kemp is someone that's ardently defended the rule of law. He took appropriate steps to protect the integrity of Georgia's election process. He certified the presidential election on November 20th, 2020, just as the Constitution and state law provide. He's now been identified as a witness in this investigation. And the most important point, Your Honor, is he has been willing to engage in this investigation since April of 2021. Despite the fact that we have the belief, as Mr. Bauer explained, that the court and the district attorney's office and the special purpose grand jury lack the jurisdiction to bring him in, we've been engaging voluntarily. Now we're in the middle of an election cycle for really the most closely followed gubernatorial race in the country. There may be one or two others that are close, but this is certainly up there. And this is happening coincidentally or otherwise, as this high profile and politically charged investigation and Governor Kemp's role in it are reaching a crescendo. The intersection of law and politics in this way, we believe, shouldn't be happening on the eve of an election. And despite our willingness to engage, we're just asking that the rule of law be closely followed in this matter. And we're going to talk a little bit about the political impact that this is all having later. But just observe, while we're talking about the special grand jury, that it's impaneled until May of 2023. The district attorney's office has publicly stated repeatedly that it is in no rush to complete this investigation. It's likely to last through the end of this year.
So that I can put what you want to share in context, because the politics of this aren't my domain. You're sharing this because it goes to the oppressive nature of the subpoena. If I find that it is not to be quashed because of sovereign immunity, no jurisdiction, or executive privilege, I'll have to hear that argument. But because I want to make sure there's a point. You have aired very publicly through your pleadings, and the district attorney has provided her perspective in pleadings about some of the back and forth and the tit for tat and the politics. That's not my space. And so I don't want to open this proceeding up to here's how we think the race is going for the governor, and we think it has this political spin or that. I don't think this is the right forum for that. And you may not have been going there, but I just want to make sure there's a good purpose for you to explore what you want to explore, since the slide in front of everyone says political impact of the subpoena.
Yeah, I'm sorry. I will get to that, Your Honor. And we are asking for quashal and or modification on several bases. One is executive privilege, the other is attorney-client privilege, and the other is the improper purpose of the subpoena, which is sort of what this overview is meant to sort of tee up. And later in the presentation, we'll be showing Your Honor, as Your Honor has seen, what the relevant policy statements are around conducting an investigation like this during an election cycle. So our position, and Your Honor may disagree, but our position is it is within Your Honor's province to take some action if Your Honor sees fit. And listen, I don't want to repeat everything we've said in our brief, and I do want to be very respectful of the court's time, but given the importance of this matter to Governor Kemp, I do want to be thorough.
We'll strike the right balance.
I'm working on it. The one thing that is a little bit unusual, and there are a lot of things that have been unusual in how this has been handled, just in my experience, is our effort to engage. For whatever reason, this interview that was supposed to happen by September of 2021, it didn't happen. It didn't happen in the beginning of 2022. It matriculates into the spring, past the primaries. At that point, we asked that it be pushed, and the district attorney's response was that it's unable to agree to push the date of a future voluntary interview past the date of the general election. That's curious to us. I'm not sure why that is, and I'm sure that the district attorney will talk about that. But that time frame, it only serves to increase the risk of unfavored political impact, which we'll get to. And so, I just say that as to kind of tee up the discussion around executive privilege, which is one of the things that we have been trying to discuss with the district attorney's office, as this court has encouraged with other witnesses since April of 21. And so I want to talk about the application of executive privilege generally, and then also specifically to this case. And the latter is a little bit more complicated because we learned about what they wanted to talk about for the first time on Tuesday evening. But I first want to address the application of it generally. And I think, Your Honor, in our papers, that we made it pretty clear that courts in other states have applied executive privilege to governors. And
So just as a starting point, you acknowledge that there is no codified, either in statute or case law, executive privilege in Georgia.
no,
You are seeking to import that concept to this situation.
that's right. And,
Okay.
in the state's response, this was a little bit unusual for me. The state says, nor notably have the remaining 49 states rushed to bestow such privilege, the executive communications privilege, upon their respective governors. By way of example, see State ex rel. Dan versus Taft, which is an Ohio case. And then they have this quote. And so we looked at that case, and lo and behold, they cited a dissenting opinion. So the only case that they cited that says executive privilege does not apply to a governor actually says it applies to a governor.
In Ohio.
In Ohio. In that case says the governor has an executive communication privilege that applies to communications to or from the governor when the communications were made for the purpose of fostering informed and sound gubernatorial deliberations, policymaking, and decision-making. The state then goes on to say, the DA's office then goes on to say, the special prosecutor goes on to say, movement cites only 2 cases to support the claim that several states have found the existence of this executive communications privilege. I thought that the pleading being 121 pages was probably long enough, but for Your Honor and the district attorney's review, we've got 10 other cases that I was going to make reference to, and rather than repeating the cites out, if I could approach and provide these to Your Honor. And I've also included a copy of the Taft decision.
Before you go further with executive privilege, I may have misunderstood in your original brief. Are you arguing that executive privilege precludes all testimony, or it, like attorney-client privilege, legislative privilege, would cabin the governor's testimony, should he testify, in certain ways? Because if it's the latter, you do need to articulate why you think there is such a thing in Georgia. But beyond that, I think we would need to work through, after we conclude today, that threshold question of, is the subpoena quashed or not? If it's not, then I think the governor falls into the same broad category as many other witnesses who have come before the special purpose grand jury, where you and your colleagues, the district attorney's representatives, and I would sit down and say, here's a safe area, an allowable area, and not. I don't think we'll do that here and now.
Well, that is a great suggestion, and one that we have been trying to facilitate for 18 months. And I don't know if there are legitimate questions about the application of the executive privilege to the governor in Georgia, but I'm happy to go through a couple of analogous cases that have similar findings. And the sites are all in front of Your Honor. In the state of Washington, in the Freedom Foundation case, the court held that the executive communication privilege applies to communications authored, solicited, or received by the governor or aides for purpose of fostering informed and sound gubernatorial deliberations, policymaking, and decision-making. In New Jersey, in the Nero case, the governor has a privilege to protect the confidentiality of communications pertaining to the executive function. In California, in the Times Mirror case,
You don't, I see they're all listed here. I can look
they
at
all
them.
apply to the governor, Your Honor. And
Okay.
so, and I understand Your Honor's point, there's not a case directly on point in Georgia saying that the executive privilege applies to the governor in the same way that it applies to the president, but the attorney general's position that it does. It's consistent with 10 other states who have found the same thing. And there is not a single case that we've been able to find or it's been identified by the district attorney that says it does not. In other words, no other state has come out and said the executive privilege does not apply to the governor. So I don't know what else really to say about the potential theoretical general application of the executive privilege to the governor. I think it's pretty clear. But to Your Honor's point, I'm happy to kind of move on to the specifics.
Okay.
And Judge, this does require a little bit of context, if you will indulge. One of the things that since we first engaged with the district attorney's office in April of 2021, when we were dealing with the initial prosecutor named Sonia Allen, we spoke with her in April of 21 when they indicated they may want to speak with the governor. We asked if we could come in and sit down and discuss areas of inquiry. They didn't respond to that. I wrote an email to the district attorney on June 16th, made the same request. I said it may facilitate the process if we can have a conversation about the areas of inquiry. That never happened. And as Your Honor is well aware, I think there are 5 or 6 other requests where we have asked to come in and sort of give a proffer of testimony so that we can facilitate these complicated evidentiary issues, despite our belief that we have no obligation to do so. And so I thought that, this issue of an attorney proffer has become kind of this controversial issue in this case. And I think that Your Honor has an understanding of what an attorney proffer is, but I just wanted to go over my understanding and what we had hoped to accomplish, because in my experience, both as a federal prosecutor and a defense attorney, an attorney proffer is one of the most commonly used tools in any significant investigation. The purpose is to afford.
So it is frequently used, but it takes 2. And if the district attorney's office isn't interested in doing that, and they think that the way to move forward is a subpoena, we got to where we are. So I'm going to ask you to focus on the subpoena, why it applies, why it doesn't, if it does apply, how you think it ought to be constrained.
I appreciate that, Your Honor. But Your Honor did ask why we're here. Okay, and how we got here. And we did agree, the district attorney's office did agree in writing to allow us to conduct an attorney proffer. Okay.
And then that didn't get to happen.
And then everything changed. On June 13th, it was unilaterally revoked. We had dates. They asked for dates for attorney proffer. I gave them dates, June 24th or June 27th. This was anticipation of a voluntary interview, July 25th. Then on June 13th, we get the rug pulled out from under us. There will be no attorney proffer. And you got to give us, by the way, different dates. Actually, we'd given August dates. And then on June 13th, the special prosecutor said, those dates are no good. You're not doing an attorney proffer. Governor's got to come in sooner. And, if you don't give me new dates within 48 hours, we're going to issue a grand jury subpoena. This is the first I'd ever heard of a grand jury subpoena, because we've been operating in good faith for over a year. And I noted the change in tone and said, well, there's no reason to threaten a grand jury subpoena. And I got well, it's not a threat, it's a promise. And, I think the last time I heard that line, I was riding around in a big wheel, but we understood that the position had changed. And so then we provided those dates within 48 hours. But the hope was that we could still facilitate some conversation about the subject matter that would be discussed with the sitting governor, who was agreeing to voluntarily come in. Okay. It didn't happen. And so, what is interesting is what has happened since. It's somewhat, and even when Your Honor was conducting a hearing on June 22nd regarding some similar issues, and Ms. Pearson asked, at a minimum, you'd ask the state, the DA's office, provide buckets to us before the people are brought in. And Your Honor said that's a fair request, and sort of worked through it. And that's what we have been trying to do. And, whether one is an experienced prosecutor or, or leading an investigation like this for the first time, I'm just troubled by the fact that we weren't treated like others, and we were not given the ability to discuss these important evidentiary issues. And, call me a worrywart, but I don't think I would be doing any client a service, let alone the sitting governor, if I were to walk that client into a meeting unprepared, not knowing the first thing what's going to be talked about. And all we were told is, well, we want to talk to him about some conversation between the Secretary of State and the president that he wasn't on, and what he knows about it and what he doesn't know about it. Well, we've now learned for the first time in a public filing on Tuesday night that the areas of inquiry are much more detailed and much more significant. And so, we'll talk about the politics of all this and the political impact, regardless of whether it's politically motivated or not. The ABA and DOJ policies focus on political impact. This has clearly had a political impact. It has a political impact when in a public filing for the first time, you list all these areas of inquiry. And so I don't know what purpose that serves. In other words, I'm trying to figure out why we were not able to have that conversation with the district attorney's office that we've been requesting for over a year. And as Your Honor is aware, the tone changed. Things, became, for some reason, adversarial. And all that we were asking in advance of what ultimately became the July 25th voluntary interview were just standard prophylactic measures that any prudent attorney would take before bringing someone in to an investigation, particularly if, as the district attorney's office says, it's a criminal investigation. I take those things seriously, Judge. And so, to Your Honor's question, the answer is, I don't know. There's a lot of information here on this page. They're talking about phone calls between people that we were never involved in. They go through this detailed, litany of information that's never been discussed with me, and therefore I've never had the opportunity to discuss it with my client. And they end by saying the district attorney submits that the above clearly relevant information is just the start of what may be revealed through Movement's grand jury witness testimony. So there's a lot there to unpack. And we would just renew our request that we be given the opportunity to discuss that with the district attorney's office, as Your Honor has suggested in other cases. And by the way, I think I've probably been involved in more than 100 attorney proffers as a prosecutor and a defense attorney. I've never had the experience of a prosecutor telling me that she wouldn't let me come in and hear what I had to say. And as a prosecutor, I've never told someone you can't come in and proffer evidence, because I know how helpful it is to the process. And I'm also not familiar, and I've practiced all over the country, and I've never had any state or federal prosecuting agency tell me that there was a policy against attorney proffers. So we've been trying to come in voluntarily, facilitate the dialogue to discuss executive privilege, attorney-client privilege, those types of things. They've rejected it at every turn. And then for the first time, they do what we were asking to do, but they do it in a public filing. So I'm at a little bit of a disadvantage to talk about the specific application of the executive privilege without knowing, as Your Honor has said, what the questions might be, how they're asked, what the subject matter is. We got to be given that opportunity to do that, and certainly would not allow any client to go into the grand jury separated by counsel and have to parse through these very complicated privilege issues, whether it's attorney-client privilege or otherwise. So, what we have proposed repeatedly and will propose again, I don't know if it's within Your Honor's power to do it or not, but it's very simple, Judge. And as Mr. Bauer says, we're a little frustrated too, but if the district attorney's office agrees to address these outstanding evidentiary and privilege issues in an attorney proffer in advance of a voluntary interview that takes place after November 8th, all of these issues will be resolved. As Mr. Bauer said, we can't waive sovereign immunity, but we will do what we said from day one and come in voluntarily. And that's all we've been trying to do, Judge. I think that executive privilege pretty clearly applies if we're talking about it generally. Whether it applies specifically to the subject matter that they want to ask them about, the answer is I don't know. It depends. I mean, we've been able to identify certain things where we don't think it applies. Happy to talk to them about it. We just hadn't been able to have that conversation.
When you say come in for a voluntary interview, I know from some of the exchanges that I've had with you and the district attorney's office, always present together. There's the notion of an interview as in before the grand jury, because they're the body that will be issuing this recommendation. And so they might have questions that the prosecutor didn't think of, versus a voluntary interview solely with the district attorney's office. So it's a voluntary interview before whom? Assuming these other attorney proffer happens, you work through concerns about privilege, all three of them, et cetera. That's a voluntary interview in front of the grand jury. It's a voluntary appearance, in other words.
It's exactly what we had agreed to.
I don't know what you.
I'm going to explain.
Okay.
A voluntary interview with the district attorney's office. That's what was scheduled and what became publicized on July 25th. In advance of that, after the attorney proffer was canceled by the district attorney's office, in a last ditch effort to discuss some of these issues in advance, we sent an email on July 20th that everybody's seen, where we asked to discuss the topics in advance, some questions in advance to deal with these issues. In response to that July 20th email, the interview was canceled, grand jury subpoena was issued. Here we are.
So the conversations that you and Mr. Wade and others and I had about finding a date that works, not just with the governor's schedule, but yours, I thought that was for an appearance before the grand jury, and not I don't need to get in the middle of, and ought not to be asked to get in the middle of, set up an interview. I was brought in because there were concerns about the reasonableness of the district attorney's office's insistence on a particular date for an appearance before the grand jury, which we can call an interview. I don't really care what label you put on it, but it's structurally different, as you know, appearing in front of the grand jury versus sitting down with representatives of the DA's office. And so I don't want to misunderstand what you're describing. Not that I get to enforce any of this other than I'm being asked to enforce or quash the subpoena. But what you can negotiate with the DA's office, that's your powers of persuasion and whatnot. So that's where I'm confused.
Well, Your Honor, I'm just trying to tell you what happened. We had an agreement for a voluntary interview. We had an agreement to conduct a proffer session on either June 24th or June 27th. That agreement was unilaterally terminated on June 13th. We were told to give dates sooner than August for the voluntary interview, or a grand jury subpoena would be issued. We did do that with the hopes of continuing to have a dialogue, of previewing some of these topics in advance to facilitate the conversation and not having to come before Your Honor, which we most certainly would have had to have done multiple times. And then in an effort, when I made those requests in advance of the voluntary interview on July 25th, that offer for voluntary interview was revoked. We were issued a grand jury subpoena on July 29th. It was at a time when I was planning to be in the middle of the Grand Canyon, going down the Colorado River, and Your Honor and the district attorney's office were kind enough to push it back 1 week. And it was during that period of time where we were trying to assess what our options were. We were put into this box, okay, where we then had to invoke sovereign immunity because we still were not given any clarity about what would be discussed. And it wouldn't be proper for any lawyer to take their client in, let alone the sitting governor of the state of Georgia, under those circumstances. And, this has all been sort of highlighted and very well reported in the media, and that will get to the discussion that we have later about the political impact. But we did not want to be here.
So I'm clear, voluntary interview is different from grand jury appearance.
Right.
Okay. All right.
Thanks.
I think I guess I'll hear from the district attorney's office. I guess we're talking about executive privilege. If you feel compelled to engage on the back and forth with the emails and invitations, do so very, very briefly. I'm more interested at this juncture hearing about executive privilege, if that's something you want to respond to.
Very briefly, Judge.
It always makes me nervous,
Well, no, and it should.
not just from you.
It just has become abundantly clear to the state that Mr. McAvoy is going to respond in a manner that he gets across a message that's not even relevant. The court has consistently stated to Mr. McAvoy and our side that the court is not interested in hearing certain aspects of even the pleadings. Mr. McAvoy has ignored that, as he has done throughout this process. He's ignored our communication. He's ignored clear communication to him because he wants to drive the way that the state is proceeding with its investigation. Mr. McAvoy clearly is not in favor of the state electing to not move forward with a interview outside of the grand jury process or the special purpose grand jury room. The state is elected to do that. That is not Mr. McAvoy's call. That rests solely with the district attorney, and the district attorney has made that decision through the power of the special purpose grand jury. Mr. McAvoy starts to talk about an email exchange between the two sides, which the court has clearly stated it does not have an interest in, and we will not go there. However, Mr. McAvoy made specific reference to his email, and I'd like to address that briefly here. In Mr. McAvoy's email, he outlines requirements. He said, these are the requirements for our client to come and sit and speak with you. One of the requirements is we are to get in advance, well in advance, each and every question that's to be asked. Well, that's not his call, and that's not the state's position. The state's position was that his client would come in and speak in front of the special purpose grand juries, just as a host of 30 plus other witnesses have done. That's all. At that juncture, Judge, during the course of the interview, what really broke down the conversation was within the email, Mr. McAvoy says that the only way that that interview would take place, the only way that a voluntary interview would take place is if we didn't record it. Well, our intent was to record it so that the special purpose grand jury could see and hear for themselves what the testimony was accurately. Well, that's an issue. We can't record it to show the special purpose grand jury accurately what was reflected during the course of the questioning. Then it becomes too much of a control issue. Mr. McAvoy was attempting to control our efforts to ascertain the information that we were seeking. Now, I did say briefly, that's brief. I'll allow Mr. Wakeford to come up and address the other issues of the court.
All right. Thank you for sharing that. Mr. Wakeford?
Your Honor, each witness who has come before the special purpose grand jury and raised an issue of privilege, if the parties, meaning members of the district attorney's office and counsel for that witness, cannot come to an agreement about the application of that privilege, it is elevated to your honor and decided based on the specifics of the situation at hand. That is still available. And if the governor appears to testify, that process would still be in place. So
True. What about the threshold argument that executive privilege, if applied in Georgia, would bar all testimony because the inquiries are about what the governor did in the exercise of his office?
I'm not sure if I understand their argument to be that all inquiry whatsoever into anything the governor did is barred by a claim of executive privilege. I believe it would just be the process of deliberation before a decision is reached. And anyway, any arguments about executive privilege don't go to factual determinations, which privilege doesn't touch. Whether something happened, whether something was said, is not reached by privilege. And so the total quashal, the absolute quashal of a subpoena, which they're seeking here, is just not appropriate. This is, again, something that we can talk about on a question-by-question basis with Your Honor participating in the process.
So if it applies, you'd analogize it to the legislative privilege, which precluded some area of questioning for certain witnesses, but allowed others. And we worked through that either, as you described it, the lawyers sorted it out, or as a group, we sorted it out.
This is just a reflection of the sovereign immunity argument. I mean, it's just the same. It's the same argument where, I don't know whether it was in jest or not, but the governor is the king. Governor is the state embodied, and therefore this court has no authority to tell the governor to do anything. That is just the same thing with this executive privilege argument, and that is not the case. There is no recognized gubernatorial privilege in Georgia, first of all, and second, it would have to be tailored to the actual questions which are being asked.
Okay. Thank you. Mr. McAvoy, you're back up. Not much of a rest for you.
No, and I'll be brief, Your Honor. I know that Your Honor does not seem to be too receptive to this argument, but I would like just to be able to briefly.
I am open-minded. Expand my horizons.
I will say that on the executive privilege, it applies to documents and other materials that reflect presidential decision-making. And it applies to pre-deliberative and post-decisional materials as well. So our view is it is pretty broad. I agree with the DA's office. We may be able to carve some things out that he could talk about, which is what we've been trying to do. Happy to do it under the right circumstances. But the problem and the final ground that we believe is appropriate for quashal is because of the significant political impact that this investigation has had on Governor Kemp. The timing of the investigation, its political impact have reached a point, we believe, where it has been violative of existing DOJ, ABA, and national prosecution standards. And they all direct that any political impact should be avoided, quote, such investigative action that could impact the outcome of an election is greatly diminished once voting has concluded. The ABA's criminal justice standards provide similar guidance. These standards, which are, quote, intended as a guide to conduct for a prosecutor actively engaged in a criminal investigation or performing a legally mandated investigative responsibility, state when, due to the nature of the investigation or the identity of the investigative targets, any decision will have some impact on the political process, such as an impending election. The prosecutor should make decisions and use discretion in a principled manner and in a manner designed to limit the political impact without regard to the prosecutor's personal political beliefs or affiliations. And finally, the ABA, the Criminal Justice Standards, Standard 3.6 on prosecutorial investigations says, whether one agrees that this investigation, and that what I just read was from the ABA. And so there's been discussions about whether this investigation is politically motivated, whether it's not, whether one agrees that it is politically motivated or not. And I think there's some evidence to suggest that it is. No one can deny that this investigation had and continues to have a political impact, which is the standard under the relevant policies. I've got a couple of exhibits, Exhibit Z and Double A, that I'd just like to publish, Your Honor. And these are just representative examples of what happened out in the world hours after we believe we were forced to file our motion to quash.
Okay.
All right. So, look, I understand you've got political candidates trying to gain traction with some segment of voters, but as an attorney and not a politician, it doesn't sit well with me, and it doesn't sit well with the policies that I've just enumerated. Obviously, we've discussed and debated, had a very reasonable debate about the refusal to testify, right? I don't think it's because he'll do anything to win an election, right? So, these things happened, as I said, hours, that's 9 p.m. on April 18th. I think we filed our motion around 4:45 that day. It's having a political impact.
But what's having that particular impact was the decision to file the motion. And I will do my best to refrain from descending into the political chaos that I know some folks really, really want to talk about, and the pundits can do that. But was not, setting aside the sovereign immunity concerns, I'm not minimizing those in any way, but setting those aside, would not the path of least resistance, least attention, least political fire from any direction to have been, we agreed on a date. You were available. You had confirmed the governor was available. Appear, come in through a secure entrance, leave. It's a non-event.
Is that
This, I may be missing it, but because it's in your brief and because you argue, look at this is, there's these political impacts, it's not fair. And per all the policies that you correctly cite, DOJ, ABA, et cetera, isn't the answer, how about November 15th to come in for whatever coming in means? Right now, that's not the posture we're in. But Z happened because what had originally been negotiated didn't happen.
That's right.
Okay.
And is that where we are, Judge? I mean, is that where we are in society, in our legal system, where I don't believe anyone should be punished politically or otherwise for the invocation of a legal right or privilege? That's what's happened here. We didn't want to be here. We agreed to something. They disagreed. They created a controversy. We had to respond. Who benefits from that controversy? Not Governor Kemp. He doesn't benefit from that. And I don't think it's fair to punish Governor Kemp for invoking a legal right or privilege that, by the way, he doesn't have the authority to waive sovereign immunity. And by raising it, what is he hiding? Judge, we're still a society that's governed by the rule of law, and the district attorney's office is free to pursue any high-profile investigation without fear, but it also must do so without favor and without the threat of impacting our election integrity. That's something Governor Kemp has fought very hard to protect and maintain. And the district attorney's office has said they don't want this to have a political impact. And I appreciate that. And so the easiest thing to do is to kick this down the road 75 days. I mean, Your Honor is well aware of where we are, what state we're in, what race we're facing. And, you know, the governor ought not have to suffer political consequences for invoking a legal right. I think the district attorney's office would agree with that. And so it's our position, there's a very simple solution for that. I don't understand why his appearance has always been tied to coming before the general election, but it has. If this investigation is going on till the end of the year anyway, special grand juries and panels until May of 23, I don't see any significant investigative harm to pushing it. It's consistent with DOJ policies, it's consistent with ABA policies, and that's all we're asking for.
Okay.
Just before we respond, we got kind of lost in the argument. 2 screens ago, Mr. McAvoy posted an opinion by the Attorney General that specifically referenced criminal investigations and criminal statutes. Well, not 20 minutes ago, the argument was this wasn't criminal. So we got kind of lost in the argument. Is it criminal or is it not? What is their position? Because if it's not criminal, then that slide 2 screens ago would not be applicable. So we're just trying to figure out which side does the court want us to argue.
I want you to argue your side, whatever that may be. I noticed the situation that you noticed. You don't have to sigh every time you come up.
Do I do that every time?
You do.
If you've
It's not
noticed
that
that
bad.
much, that's a sign I've been before Your Honor far too much. Okay, so refraining from sighing, Your Honor. The district attorney publicly stated earlier in 2022 that although this special purpose grand jury was impaneled in May, it would not begin conducting business until June, specifically to avoid public activity in order to avoid interference with the political primaries, which were decided in late May. In those contests, perhaps no one was more visible for obvious reasons than the governor's own contest against an opponent whose involvement and opinions about the matters relevant to this special purpose grand jury could not have been more public, more vehement, or more vitriolic if you watch the debate between the two individuals before the governor's primary. That was a specific delay, which the district attorney publicly stated she would take. She would decide to pursue. After communications break down, there is they break down because of a July 20th, 2022 email in which requirements for the governor's voluntary interview are stated by Mr. McAvoy. And the word requirements is very specifically used. Another phrase that is used in that July 20th email is politically motivated investigation. It has been their position since before the voluntary interview could not move forward. Before a subpoena was issued, it was their stated position that, well, this is a politically motivated investigation. They put it in writing to us. What is the district attorney supposed to do with that when she has already tried to move the date of any involvement past an entirely contentious primary that the governor was participating in? When the district attorney had engaged in negotiations to have a voluntary interview, even after the special purpose grand jury was seated and was subpoenaing other witnesses. As in deference to the respect afforded the office of the governor, communications and negotiations about a voluntary interview continued until requirements were stated by the governor's office, because in their words, this was clearly a politically motivated investigation. At that point, what more is there to discuss? There was an agreement to a date after a subpoena was issued. There was an original subpoena date. And then there was a conversation in which Your Honor participated between the parties where counsel for the governor pointed out, I can't do that date for personal reasons. I can't be there on that date. And so there was an agreement among the parties that another date, 8 days later, would be appropriate. That was agreed to. Another subpoena was issued and accepted. And on the day before that agreed to date of the 18th, they filed this motion. All of these issues existed. All of these positions they have didn't arise in the 8 days, 7 days between when they agreed to a date and they filed their motion. And finally, I think this is very important to understand, where they're saying they're being persecuted for raising this position. Well, one, they decided to raise it on the eve of a date that they agreed to specifically after requesting that it be moved. And additionally, the media, as we point out in our brief, the media had already reported, incorrectly as it turns out, that the governor had appeared and provided testimony, whether it was in a voluntary interview or before the special purpose grand jury. This was reported in the media widely that on July 25th, the governor had appeared and provided testimony. No one from the district attorney's office contradicted that. No one from the governor's office contradicted that. The story was over. There were no statements by anybody else. There was not a firestorm. There was not an eruption of controversy. It was quiet. If the governor had appeared on August 18th, driven into a secure location, been brought into the building, appeared, provided testimony, left, there would have been no story. There would have been no controversy. There would be no political implications. There would be nothing to talk about, because the story, for the media's purposes, was over. There was no testimony to hear about because it had already happened. But instead, they waited until the day before the governor was supposed to appear, to the date that they agreed to, and then they filed this motion and made public statements about how they could not cooperate at this stage. So to continually insist that this is a situation engineered by the district attorney's office to the intentional detriment of the governor is just not true. The facts before the judge make that clear, and to insist otherwise, well, Your Honor can make your own determinations about the validity of those arguments. That is the district attorney's position as to this. If he had just come in, we had talked about these issues even with you that day, there would have been no story because the story was already over. Instead, the governor's counsel created the story by not just choosing to file the motion, but choosing to file it in this way after getting the date that they requested. Thank you.
You're welcome.
Your Honor.
So I don't want to hear any more back and forth about who had what agreement about voluntary interview or not and dates.
Okay.
I'm now familiar with the timeline,
Sure.
and of course, none of this impacts sovereign immunity and jurisdiction, but it does go into, if that argument fails, how do we structure things going forward? And I feel very comfortable now that I understand not every aspect of the back and forth, but enough to make some informed decisions. So if there are other topics you want to cover, Mr. McAvoy, in connection with the motion you filed that brought us here in a public setting, I'm happy to hear other topics.
Well, I just want to reiterate its impact. It's not intentionality. It's the political impact. And no one's denied that there is significant political impact. And that's the concern. And certainly it would have been impactful had we gone in voluntarily on July 25th and given a statement in which we were not fully prepared and it was recorded. And one of the things we asked for was to enter into a non-disclosure agreement. So it wouldn't be, and they wouldn't do that, right? So then we bring in the governor to a voluntary interview that, they put in a publicly available document so everybody would know about it. And if it didn't go well and there was no 6E grand jury secrecy protect, what would have happened? I mean, we are damned if we do, damned if we don't. We come in, it's going to be politicized. We don't come in, it's going to be politicized. We invoke legal rights, it's politicized. And we are just in a difficult position, which underscores the difficult balance of conducting a high profile political investigation in the middle of an election cycle.
And Judge, if I might.
You mightn't. It's okay.
Yes, sir.
I would, unless it's a different topic. If it's in response to what Mr. McAvoy said, I think that was a good resummation of what he already said. Good meaning accurate. I think it fit what he said before. Nothing new. So if you are going to address that same thing, we've covered that turf. But if there's another topic that you'd like to cover, by all means.
Another topic, Judge, but it's dealing with the issue at hand, which is we propose that we treat this witness just as we treated other witnesses, which is the day Mr. McAvoy comes in with his client, the morning of, we share with him our buckets. After we get through sharing with Mr. McAvoy the buckets, he can then speak with his client. They can get their plan of action, and we can start the examination process.
It's a tried and true method that has worked for many similarly situated individuals. So I think if and when we go forward, that will be the model that we use.
Yes, sir.
Mr. McAvoy, Mr. Bauer, Mr. Dove, anything else that you want to get before me, since we're all together right now in connection with the motion to quash that you filed?
No, Your Honor, we didn't discuss attorney-client privilege, but I think the same parameters apply.
Definitely. And insofar as the governor might have a reason to raise a legislative privilege because of some role he has with the legislature, preserved, protected, and would be navigated if we get to that point of, he's confronted with those kinds of questions. Okay. The PowerPoint that you put up, is it in here somewhere? Is it one of those tabs? Or is this just all the emails again?
I've got an extra copy for Your Honor.
That'd be great. I don't need it right now, but before you leave, if I could get that, I kept trying to find some of your slides because they'd come off the screen and it was just all the emails. Please. Thank you. Mr. Wade, Mr. Wakeford, anything else from the district attorney's office at this time?
Nothing else from the state. Thank you.
Okay. So as I see the sequencing, I need to work through the sovereign immunity issue that the lawyers for the governor have raised, that Mr. Bauer articulated here in court. If I agree with Mr. Bauer's arguments, then there is no jurisdiction that this court enjoys to enforce any subpoena. And then the two sides would need to discuss other ways in which to get information from the governor if that's how things would flow. It just wouldn't be anything I'd have any role in. It could include appearing before the special purpose grand jury, but that would be because everyone agreed to do that as opposed to anyone was compelled to do that. If I end up agreeing with the district attorney / state's position on sovereign immunity or lack thereof in this context, then we'll need to have discussions about how to move forward. And I will spend some time before we would have that discussion thinking through the concerns Mr. McAvoy raised about the political impact, not the motivation, but the impact of having not just a sitting governor, but a governor who is in the midst of a race for his office, whether that should occur, his appearance before or after the election is over. So I'll need to make both those decisions before we would regroup. And if the decision is favorable to the district attorney's office, I'll need to let everyone know my thoughts about the timing of an appearance. And then we could discuss procedural next steps. Is there anything, Mr. McAvoy, that you think I should be working through in it, or Mr. Bauer, that I should be working through in addition?
I just want to make sure that it's on your radar that if you are inclined to deny the motion to quash on jurisdictional grounds, that issue should go up on a certificate. It is an interlocutory issue. It is a discretionary appeal, but if you look at Turner v. Giles, which is a 1994 Supreme Court case, 264 Georgia 812, that kind of immunity question, the Supreme Court has said, barring some exceptional circumstance, mandating a different outcome needs to go up on an interlocutory basis.
So I'm hearing you say two different things. It's discretionary or not discretionary. Discretionary, whether the Supreme Court would hear it, or it's discretionary as to whether I would issue the certificate of immediate review.
Both. And
I guess it's always at the top end, whether they want to hear it or not, but regardless of their, I don't control what they do. I focused on what. So you're saying it's discretionary, except under Turner, it's not discretionary.
Well, the Supreme Court says under our appellate statute, it's not an automatic right of appeal. It's not considered a collateral order that you get a direct appeal without a certificate from the trial court. But what Turner says to the trial courts is,
you better issue a certificate.
So take a look at that decision, Your Honor, please, because we will ask you in that circumstance to give us one.
Okay, can you give me that site again, please?
Yes, sir. Turner v. Giles, 264 Georgia 812.
So it's a non-discretionary discretion.
Couldn't have said it better.
Yeah, no, the Supreme Court could say it better, apparently. Okay. I assume there would be appellate ramifications to whatever decision I make. But I'll read Turner and see what I need to do. All right. Anything more from the district attorney's office? All right. Well, everyone, thank you for your time. Appreciate it. We are concluded here, and I'll be in touch.